Welcome to U.S. Tales. Today we are going to talk about the U.S. Supreme Court decision on affirmative action in university admissions. The U.S. Supreme Court declared in a landmark ruling that colleges and universities can no longer use race as a specific criterion for admission. In a landmark decision, the Supreme Court invalidated racial preference admissions policies at Harvard University and the University of North Carolina. Long-standing affirmative action policies that sought to enhance the proportion of Black, Hispanic, and other underrepresented minority students on college campuses are virtually ended by this ruling. Writing for the conservative majority, Chief Justice John Roberts claims that the lack of quantifiable goals and racial stereotyping in Harvard and the University of North Carolina's admissions policies violated the Equal Protection Clause. The interpretation makes it virtually difficult for institutions to take race into account when admitting students, notwithstanding the court's insistence that it is not explicitly rejecting earlier affirmative action rulings. Strong objections are raised by the justices who dissented, highlighting the setback to progress and the effect on equal protection. The ruling was based on an appeal by Students for Fair Admissions, an organization opposed to affirmative action. It is anticipated that the ruling will force schools and universities all around the nation to change their admissions procedures. The decision was criticized by President Joe Biden, who also urged educational institutions to continue their commitment to a diverse student body. In the majority judgment, Chief Justice John Roberts underlined the need of evaluating pupils as unique persons based on their experiences rather than their race. Although the decision does not directly reject earlier affirmative action decisions, it substantially limits the power of schools and universities to consider race when making admissions decisions. The court stated that although colleges cannot create racialized admissions processes, they may still take into account personal essays that address how race has affected an applicant's life. The decision appears to exclude military service academies from its application, recognizing potential differences in objectives. Many organizations, businesses, and military officials have backed affirmative action as a way to reduce racial inequality and advance various viewpoints. However, the decision implies that universities should take into account additional elements like racial prejudice, economic background, and difficulties faced. With 3 justices who dissented in a 2016 affirmative action case and 3 justices who were chosen by former President Donald Trump, the decision represents a substantial change in the court's makeup. The consequences of the decision go beyond higher education since they relate to America's complicated history with race, which includes slavery, the civil rights movement, and recent racial justice demonstrations. Justice Clarence Thomas noted in a concurring opinion that earlier decisions supporting affirmative action had essentially been invalidated, despite the fact that the decision does not explicitly contradict precedent. The ruling is anticipated to spark continued legal disputes and national discussions about college admissions practices. Share your thoughts on the impact of affirmative action decision in the comment section below. What do you think about its effects on college admissions and communities of color? Drop a comment below and join the discussion.